Okay. Good morning, everybody. I'm Barry Broad, and with me is Ralph Lightstone, and who is he and I comprise the regulation subcommittee of the board. Todd Ratchin is here. He's our chief board counsel and intimately involved in the drafting of what we did here. Santiago Avila Gomez is here, our executive secretary, and he's going to say a few kind of introductory things related to Spanish translation and that process. Santiago?
Thanks, Barry. Good morning, everyone, and thank you for joining the Regulation Subcommittee workshop. We are offering English to Spanish interpreting services and ask that everyone who has joined via Zoom, not telephone, sorry, I'm admitting folks as I do this at the same time, to navigate to the bottom of your screen and click on interpretation and choose English or Spanish. If you're not needing interpretation, to ensure your sound quality, please select English nonetheless. Buenos días y gracias por unirse al taller de subcomité de reglamentos. Estamos ofreciendo servicios de interpretación de inglés a español y pedimos que todos los que se hayan unido a través del Zoom o por teléfono naveguen hacia la parte inferior de su pantalla. Allí van a encontrar un glóbulo que dice interpretación. Por favor, elija su idioma de inglés o español. Aunque no vaya a necesitar los servicios de interpretación, por favor, para asegurar la calidad del sonido, seleccione inglés. Gracias.
Okay. Welcome, everyone, and we're glad to see that so many people are attending. To sort of set the table for what we're going to do today, we're currently in what it still is a informal process leading towards rulemaking. So as Santiago stated, today's meeting is a workshop, which means that it's intended for interested parties to educate us about what they think about the proposed regulations that our subcommittee has come up with. These are, if and when we move forward to propose something to the board, in other words, if we take these regulations as they are now, or if they're modified, our regulations subcommittee will go to the full board at a public meeting and propose that these regulations be put out for adoption by the board. At that point, the formal rulemaking process begins. So this is a real opportunity to talk about what you feel about these regulations. We are implementing a statutory change of great significance. It was a big bill, AB 113, and it changes our process significantly. These regulations are intended to implement that process. It's important to us. I mean, I know, having been a lobbyist for 40 years, I know that sometimes the temptation is great to want to, in a sense, relitigate the arguments of contending parties that led up to the passage of a bill, or to say how much you hate it or like it or whatever. That's perfectly okay for you to do. It's not particularly helpful. We need to implement these regulations and get it right. So one of my biggest fears when I used to propose legislation, and for those of you who are involved in that process will understand what I'm saying, is you can expect to have disagreements between, say, business and labor over how to proceed changing labor law. But oftentimes my biggest fear was not that I had a good bill from my side and it was viewed as a bad bill from the other side, that's sort of often a given. But that I would get it wrong in the details, that I might come up with what I thought was a perfectly great idea on behalf of the people I represented, but if it wasn't workable, if it had flaws, would have flaws fundamentally in its implementation, that's a huge problem. And I often felt that the biggest amount of help I got in solving that problem, ironically, came from the people who on the other side, who sometimes said, well, I don't, we disagree. You got it right. I mean, you got it right, but you're wrong in what you're doing. But, yeah, I get what you're doing. But sometimes they would say, it's a bad idea. And even if it was a good idea, you're doing it wrongly. Our job is to implement this legislation and to do it faithfully to to the intent of the legislation, to make it workable. Those are the purposes. That's the purpose of this regulation, to make the process workable. So to the extent that you can tell us what we've omitted, what we've gotten wrong with regard to making the process workable, that would be the most helpful thing for our subcommittee's work, because we want to get it right, and we recognize and respect that there are people probably in this meeting who oppose that legislation, still oppose it, wish it was never passed, but we're not, we can't, even if we wanted to, we can't repeal a law. We just have to implement it. So the most helpful thing will be to tell us, this portion of the regulation, it's not faithful to what, it doesn't implement what the law says. You've got it wrong. It should be done a different way, so that we can feel confident that, or reasonably confident, as we go into the formal rulemaking process with whatever we produce as a final work product of our subcommittee, that we've given or recommended something to the full board that we feel with reasonable confidence is a workable approach, that it faithfully attempts to implement the statute itself. Now, I just want to, for those of you who aren't familiar with the regulatory process, I just want to make it very clear. Once the board proposes a regulation, a formal comment period begins. So nothing is cast in stone at that point. The board could do anything from adopt it as we propose it to reject it altogether and tell us to go back to the drawing board. And of course, anything in between. So nothing is cast in stone in this process. We've had this kind of public process, that sort of this board that exists now, through a series of regulatory changes that we've done, some of which were very kind of technical, and some of which, like this, are likely to be more controversial because they implement a controversial bill. But we've wanted to have this informal process beforehand because it really helps us shape our sense of whether we're doing it right or not, and what changes need to be made. So with that, I will basically open this up. I want to say that you're perfectly free to say whatever you want, obviously, but you're perfectly free to respond to other people, to say you disagree with them. This is an informal process. It's more like a conversation than it is like a formal hearing. And we'll probably ask questions, maybe even probing questions about what your point of view is, because we really want to understand it from all perspectives. So with that, I will open it up. And then let me recognize Ralph for a few words.
Yeah, Barry, thank you. And thank everybody for being here. I just wanted to add, reinforce the point that there are going to be further opportunities to comment. The other thing is, I think by way of process, what we had in mind is for Chief Counsel Todd Ratchin, who is in the Zoom here, to walk everyone through the draft that we have posted for people to comment on. And I think it'd be better if people let Todd go through that whole thing, and people will want to talk about a number of issues that are in the draft. But let's have Todd walk us all through that, and at the end of that, let's open it up for comment.
Yeah, thank you, Ralph. I got the script wrong. My first apology of the day. Okay, Todd, why don't you go ahead?
Okay, yeah, thanks. And thanks everyone for being here. So I'm just going to do a quick walkthrough of the regulations. I know we published them. Hopefully everyone's had a chance to review them. We thought it would be helpful in laying out the proposed language to sort of flag where we are modeling the processes based on existing practice and regulatory language. And so the two main components of the bill, AB 113, are the majority support petition process and then the appellate bond process that will require some restructuring of our compliance regulations and determination of monetary remedies prior to judicial review of a board decision taking place. So, we're trying to, take, the amendments to the act and fit the processes within procedures that, our parties, folks that practice before us are familiar with, and that will be consistent with other procedures that we currently handle. So, I'll just go through, I'll try to be quick, but kind of go through them piece by piece, starting with the majority support petition process. This would be proposed regulation 20391. Up in subdivision A, it's basically covering the filing requirements that are laid out in statute. So really no new requirements here, except in terms of service of the petition, borrowing other regulatory language to make it consistent with those processes. In terms of the contents of the support that accompanies a petition, this would be authorization cards or signatures, petitions containing employee signatures. And so in terms of the contents of what the cards or petitions must contain that we'll be looking for, we've modeled that after existing regulatory language for a normal petition for certification. And so, the cards or petitions must be signed, dated, the signatures are valid for 1 year from the date of signature, and then language indicating that the employee or employees authorize the union to serve as their collective bargaining representative. So that's based on existing language for the current requirements for a certification petition. Then moving down further into subdivision B, this is the employer response to a petition. Again, it's modeled pretty closely after existing language, the same sort of time frame for an employer to respond, which is also set out in statute. And then, moving further down, subdivision C gets into what the substance of an investigation will entail, which is primarily as described under the statute. And I'll just say here that a lot of the process is already laid out in statute, and so there wasn't a whole lot of the heavy lifting in terms of crafting the details of the process is largely already covered in statute. So that's sort of the the hand that we're playing here. But this will entail the regional director where the petition is filed, comparing the names and signatures on the support to the list received from the employer. Also inquiry into issues about the scope of the bargaining unit, whether peak requirements are met for the timing of the filing of the petition. And then if the support provided with the petition is insufficient, the statute provides a 30-day cure period to the filing labor organization. And so the board would notify, or the region would notify the parties, and the labor organization would then have the opportunity to gather and submit additional support, or to cure deficiencies on support that may have already been submitted but was deemed invalid for some reason on the cards. If the support is deemed to be sufficient, they've the threshold 50% majority showing is made, then under the statute the board certifies the labor organization, and that will trigger a time period for an employer to file objections to the petition. This would include grounds based on existing language, whether there was improprieties during the investigation, or whether there were questions with the support submitted. But these, the grounds for objection and the process for handling objections under this statute are modeled after the existing regulations governing the objections process for a petition for certification. So again, trying to stay as closely in line with our current practices and procedures as possible. I'll just skip down to under subdivision F of the regulation. The statute lays out procedures regarding if a second majority support petition is filed while one is already pending, and that the second petition basically gets held in abeyance until the first filed petition is resolved. And so that's what subdivision F of the regulation is seeking to implement, how the board would handle these situations where a second petition is filed. And under the statute, the only circumstances where the board would begin to entertain the second petition is that if it contains allegations of employer assistance, support, domination, and so there's the subparts of this paragraph lay out how, what the board would be looking at, and the criteria and requirements in terms of when those types of allegations would warrant a hearing. And then the statute sets forth a 3-month time period for those types of allegations to be resolved. And so the process is designed to be expedited to meet that requirement. One aspect the statute doesn't cover is consolidation with unfair labor practice proceedings. And so that's, skipping down towards the end, subdivision G of the regulation, that's intended to cover similar to existing practice with certification petitions where objections may be consolidated with pending unfair labor practice charges. That's what subdivision G is intending to cover and address. Again, we've tried to model the language as closely as possible on existing practice. So we're not reinventing the wheel here. And then the final piece of this regulation is addressing the final subdivisions of the majority support petition statute 1156.37, where the final subdivisions of that statute set forth certain unfair labor practice, liability consequences for certain employer conduct while a majority support petition campaign is underway. And so this final subdivision is seeking to implement that piece and when the board would consider a campaign to be underway for purposes of triggering the provisions of those subdivisions of the statute. So that's that. And then the appellate bonding restructuring of the bill is pretty significant. There's a lot of process in here that, I won't bother getting into the details, but please, if folks who have reviewed it and familiar with the processes, if you see anything, feel free after to jump in on that. But the overview here is that when the board determines that an employer has committed an unfair labor practice and a monetary remedy is owed, the statute directs 1160.3 directs the board to refer the matter into subsequent proceedings to determine the amount of the monetary remedy. And this would take place before judicial review of the board's unfair labor practice liability decision is available. And so after the board were to issue a decision in those circumstances, the process is designed so that the board would refer the matter directly back to, I think the ALJ, one of the ALJs, and then set a 90-day time period for the region to issue a specification for calculating the amount of the monetary remedy. And this is in keeping with 1149.3, which requires compliance proceedings involving monetary remedies to take place or to be completed within 1 year. And so we're trying to operate within that time frame. And so then after the specification is filed, the process, it's basically a lot of the same regulatory language, just restructured or reordered. And so the process would then proceed very similar to how it does under current practice, where the parties, if there's disputes, would litigate those issues. It would result, if it goes to hearing, in a final administrative law judge decision recommending the specific amount of the monetary remedy owed, at which point review before the board would be available. And then after that, when the board settles on a specific monetary amount, that would then be the amount of the bond that would have to be posted as a condition of seeking judicial review. At which point the liability questions and any issues that arise during the scope of the remedial proceedings would all be subject to review in that single appeal. So it would sort of be review of the entire process, leading to both of the board decisions at issue. So that's the overview. I think I've covered everything, hopefully, but I'll turn it back to Barry and Ralph if you have anything to add. Otherwise, I think we're ready to.
Okay, so here's how we're going to proceed. There is a public comment queue. Some people are already in it. Santiago will call the people in the queue. We're not going to do the raising of hands thing because it's very hard to track who comes first and who's there. And the public comment queue actually allows us to keep, to kind of get it right, where it's sort of first come, first serve, so to speak, and to make sure that when we sort of form or write out a record of this meeting, that we actually include everyone and don't miss anybody. So with that, I'm going to turn it over to Santiago to call the first group of people and to tell you kind of how to get in the public comment queue if you haven't figured it out yet. So Santiago.
Thank you, Board Member Brad. So initially, we have a queue of 3 parties wishing to make comment. For other folks in the meeting who wish to join the queue, you may do so by either using the chat feature in Zoom, allowing you to send me a message indicating your wish to provide public comment. Alternatively, you can email me, and that's at santiago.avila-gomez with a Z at the end at alrb.ca.gov. Right. Moving ahead to the first party in the queue, it's Barsamian and Moody attorneys. Ron Barsamian, Pat Moody, and Seth Meriden. Beforehand, I let you know, I'm sorry if I butchered your name in any way, but at this time, Barsamian and Moody attorneys may commence public comment.
Okay, well, thanks, Santiago. This is Ron Barsamian. First off, I appreciate the whole approach you folks are taking on this very important legislation and regulatory process by having a workshop. We did this years ago during Gould's time, and even before then when we were revisiting access, for instance, for example. So this is a good process. I think it's a good idea, and I think it ought to be used more often. Might not have been a bad idea to use this for some of the procedural regulations that we just dealt with, since at least with the attorneys, we have to deal with those things. But in any event, as you said, Barry, we're left with this, so I'm not going to scream, yell, or go nuts about the legislation. Just assume I would be. I'll talk about what I think needs to be done with the regulations based on the draft before us. Most of this has to do with the authorization cards and the petition alternative. My biggest concern, doing this for 4 decades, is the abrupt change in what these authorization cards mean. This is not the NLRB, where the employer can still reject the authorization cards and the card check and call for an election and get a secret ballot election. Even in New York, under their PERB regulations, there can still be an election. And I don't know if Carl's in the queue or not, but Carl Borden could probably speak to that since he took a look at that. My biggest concern is these authorization cards, the minute they're signed, may very well become votes in and of themselves. Obviously, card check is just an alternative. The union can still file for a regular secret ballot election, but chances are they're going to try for the card check. And by card check, I mean the majority support. I'm just using a generic term. I think the cards need to be changed. There needs to be a requirement here because of the change in this law. And this will not have any effect on a union's security rights or their ability to govern their own membership rules. This is because the cards can be used as a vote, and because everything farm workers have been heard for decades is, sign a card, you're still going to get a secret ballot election. Everything they've ever heard about the history of Cesar Chavez, he fought for a secret ballot election. It's been the whole key. Now we've changed it. Won't argue about why or whether it's a good idea, but it's been changed now. Those cards become a vote. It's as if somebody's standing next to you in a ballot area, watching you as you vote. I think there needs to be information on the cards and or on the petition that is very clearly communicating to the employee that this authorization card, if you sign it, may very well be your vote. You are not guaranteed a secret ballot election down the road. This may be it. Secondly, there needs to be very clear and concise language on both the authorization card. And of course, this can be difficult with the petition. So maybe if they're using, petitions to be signed, maybe something needs to be given, a sticker like the little voting, I voted today type of thing, given to the worker that says and explains exactly how they can withdraw their support. We don't know why the workers are going to sign these authorization cards. The UFW is very, very, and I'm picking on the UFW because I think they do this more than the Teamsters or the UFCW. It's in their roots. They're a very good social organization. They do a lot of things for people. They help with immigration. They help with credit. You can get discount cards at Disneyland, for crying out loud. There's a lot of reasons why people might sign an authorization card. So I think they need to know that there's another purpose for these cards, and it needs to be clearly stated about how they can be withdrawn. And I'm not too impressed with the idea. I know New York talks about this a little bit, and I know there's been other discussions with this even in our own processes here when the cards were just used for getting Excelsior list or what have you. Sending a withdrawal in this case to the union, I don't think is sufficient. I think there needs to be a form provided and a process even before these cards may even be used, to where a withdrawal can be sent directly to the ALRB, because it's the ALRB that's going to be getting the support, the cards and or the petitions. And if the ALRB needs to keep a bank of those somewhere, so be it. It's computerized. I hear there's a big locker in the Visalia room where thousands of ballots were kept for years on end. So there's evidently some kind of recourse there for keeping things safe. But I don't think sending that to the union itself is sufficient as far as providing safeguards to the employees. But again, two things so far. One, an explanation on the card, on the petition, or on a handout when they're using a petition, making it clear to the employee that this may constitute their vote. They may not get a secret ballot election. And two, how they can withdraw it if they're unsure, or maybe because they've changed their mind. I think there needs to be something very clearly stated in, and it's going to be I think A1, but maybe A2, a clear statement that there can be no electronic signatures, period. You can't allow it in this situation. I think the board needs to issue new pamphlets. The old certification pamphlets just don't do anything for this card check. I think new pamphlets need to be printed out, things that organizations, whether they're unions or anybody else, can hand out. So it's a statement from the state as opposed to a statement from a union or an employer to the employees in the state's own language as to what a majority support petition is and what signing a card or a petition means. There was, when Todd was going through this, I picked up some other. Oh, on C, there's a discussion. Todd, you mentioned, talks about the RD is going to be comparing the names and the signatures. One thing I don't see in here, and again, I know you refer back to the current regulations, but there's nothing in here, and I think it's specifically going to be needed, restated if necessary for the card check program here, and even the petitions, about a process where signature examples can be provided by the employer. So far, we're just talking about lists of employees. When an employer receives these cards under the NLRB, they have the ability to go look at W-2 forms, I-9s, what have you. Here, the LRB's got nothing. And under the current process, there's not a lot of opportunity. There is when the NA is filed, NO is filed, but not when an election petition. But thought needs to be given to, especially if it's a large employer, some timing beyond the 48 hours to provide signatures, especially if we're dealing with farm labor contractors and we need to make hard copies of documents, because that's not going to be something you're going to find electronically filed already, but it's going to be W-2 forms, I-9s, redacted, of course. Anything else, employment applications that might have signatures. Because in reality, nobody's going to be walking up to an election area table to check in with the ALRB agents and the observers from the parties to go down a list, see the face, show maybe an employee identification card or what have you, and have people confirm whether or not it's the person that's on the voting list. Here, it's a signature, could be done 11 months beforehand. To rely on the regional director to only just have the names and somehow declare them valid. No, and we all know there's so many common usage of names in this industry that's not going to suffice. That proves nothing. You might as well just challenge everybody on a card. So there needs to be some process there for providing signatures specifically for the majority support petition. You also pointed out on H that there needs to be some showing of interest, 10% showing of interest to show that a organizing campaign is going on. And I presume, Todd, you're referring to the presumptions that can be raised under the card check, which is, you know, thanks to whoever came up with the idea of getting rid of overwhelming evidence, because I talked to people at the Hoover Institute and they couldn't figure out what the hell that meant. So I'm glad that went away. I don't know who came up with it. Maybe Edgar did. I don't know. But are you saying that they have to file something to show they are at 10%? Or is that going to be some backwards approach where you go backwards and say, oh, you did something 2 months ago, and we've just now received evidence at that time that they already had 10%. What we need a process there. If they're going to file a 10% showing of interest like they would for a notice of intent to organize, well, then it needs to be stated. In other words, if there's nothing filed, how the hell is anybody going to know that there's an organizing drive going on pursuant to subparagraph H? Is there going to be a new specific form for a response to a majority support petition? I presume there will be, but because there's going to be certain things that are different in there, and maybe that could contain some instruction on providing signatures. On the I see that you're talking about objections within 5 days. What about challenges? There doesn't seem to be anything in there about time limits for filing challenges. Normally, that would be done at the little table when somebody walks up to vote, get their ballot. When does that process take place? We need some procedures on that. Is that something the employer has to do with its response to the petition? That seems a little bit strange, because at that point, they're just trying to get an employee list. And if any of you have been through that in the ag setting, 48 hours, damn tough. So, especially if you got contractors. So there's going to be other issues. I suspect that once that initial list is given to an RD, more so than the current petitions for certification process, there's going to be ongoing discussions, processes going on between the RD, the union, if you will, and the employer. There's going to be more information as it comes on. I'm thinking back to, I don't know if Edgar remembers this, but the last wonderful organizing campaign we went on through. I mean, that process was almost hourly, if not daily, just because more and more information had to be obtained, because there was different issues about the bargaining unit and all that. I think here, because there's gonna be, and really think this through, guys and ladies, there's gonna be a lot more put on an RD handling these petitions than in a normal election petition situation. They're gonna be doing a lot more work. They're gonna have a lot more obligations. And there's gonna be, we're not providing them much more time. I don't know if the legislation would allow any more time to be added, but it's damn difficult for me to understand how all that's gonna happen, especially if signature examples are given, and I think they're almost gonna be absolutely necessary given card check. And again, because this is mandatory and because these cards are being filed with the ALRB, not being provided to the employer, who could sit there in their payroll office and actually check signatures like it is under the NLRB. I've got some comments about the appeal bond, but just the processes here. I don't know if you want to just talk about the card check, so to speak, or you want everything we got to come out all at once, because I think things are going to be forgotten, what have you.
Well, I think all at once is probably a better approach rather than us dividing it up. And I think given the comments you've made so far, it would probably be very helpful for you to make sure
about the
you,
appeal.
get this into a written form so that we can actually.
And this certainly isn't all. We've got a lot of questions on the attorneys, on those of us that might be filing it. Appeal bonds. Edgar, you can go to sleep on this one. I'm trying to imagine a situation where you got to worry about it. Let's say a bag of cash comes into the ALRB for the appeal bond. Where are you going to put it? Where are you going to keep it? Does it go into the farm worker fund? Are you going to create special trust fund bank accounts for each case rather than earmarking? And you know, I have questions about that process. But if a normal corporate bond is filed, Barry, you know this, if you're in court, you're filing that proof with the court, and there's a whole process there. Are we supposed to be looking at the rules of court processes, or is this something that's going to be set up separately with the ALRB? That's where we're really in doubt. Obviously, I would recommend the rules of court. It's there. But I don't know if you guys feel constrained and think that you actually have to hold the bond. I would think it ought to be held by the court, just because that's it's going to really mess up people if we start up a whole new process here. And then we get into the questions. Who gets to decide whether to cash in that bond and for how much? You know, if one agency does that, that's actually a party in the case. I have a lot of questions raised about that. Whereas a court order saying, go ahead, pay the bond, go ahead and cash in on the bond. I think that's why we set it up that way in civil litigation. Those are my big issues on the appeal bond, the big black holes, if you will. Just somebody that does civil litigation, when I'm looking at this, it's like, wait a minute, what do we do here? What's going to be different? What isn't going to be different? I guess my other concern about, and I heard what you were saying, Barry and Todd, the processes are already there for figuring out remedial monetary amounts. And I understand in some cases, small discharges, whatever, it may all be done at one time. But that, Todd, you didn't point that section out, but that's already currently part of the regulatory scheme. So I presume that would be in this case as well. Obviously, in a bad faith bargaining case, you're going to have to wait till the end and all that stuff. But I'm just wondering, are we saying that if I'm reading this right, if I understand you correctly, we'll get to the end, get a financial amount, go through any board review of that, and then that's when the board would issue a final decision and get the clock running. I assume that's what you have in mind. It's the only thing that makes sense to me right now. That's good. Go ahead.
That's how I see the statute operating.
Me too. Me too. It doesn't. That's going to take a while. I don't think there's going to be 100 cases filed almost, immediately or anything like that. But in any given case, that's going to take a while. So is that going to put pressure on the general counsel and the executive secretary to have more cases where the remedial parts of the case are part of the hearing in the first place? If so, and I've seen this many, many times, it sounds like a great way to save time, but those hearings go on and on and on. And it may be a situation where it's defensed and all that time was wasted for nothing. It also makes it tough on farm workers and other agricultural personnel that may have to testify twice, being called back on cross-examination, where they're testifying about the liability phase, the underlying ULP, and then all of a sudden we're talking about the remedial stage, and questions are raised about, did you go out and try to find work and all that stuff? That's what could really extend these cases out. Even in civil litigation, you see that. Here, it would even take longer. So I think some thought needs to be given on how you deal with that and where you're going to cut the size of the case and say, no, we're not going to combine them when it gets this big. We'll have to do it separately in a bifurcated fashion. But up to this point, if it's a question of discharge of one, two, a few people, even an entire crew on the same day and all that I can see. But you start getting beyond that, you're almost going to have to bifurcate it just because of the length of time in the first hearing. My thoughts. I may have others, but I'll shut up for now.
Thank you. That was very helpful and very detailed, and we appreciate it. And like I say, I think it would be, for us, it would be great if you would reduce these comments to writing, because sometimes in that process too, you kind of refine your own thoughts.
Oh, I plan to. I just didn't want to turn.
Right.
I mean, I didn't have any time to do it before this. I've been in negotiations, but no, I plan to, and I think others have the same plan on the employer side. We wanted to get our comments out, be able to respond to other folks' comments. But yeah, we'll be submitting stuff to you as a follow-up.
Okay. All right. Santiago, can you call the next person?
And the next speaker will be Pat Moody.
I have nothing to add beyond what Ron added.
Thank you. And that leaves Seth Meriden from your office. Will he have public comment?
Same. I will, just echo Ron's comments and submit on that.
Thank you. Next in the queue is the Martinez Aguilas Ocho Law Inc. Attorney Edgar Ivan Aguilas Ocho.
Morning. So I'd like to, so effectively, I'm making a statement on behalf of the United Farm Workers. We've reviewed these draft regulations extensively. We really appreciate the work of the subcommittee and Mr. Ratchin on drafting these. We think they fairly reflect the purposes of the bill. They're set out clearly and concisely in terms of how the new majority sign-up procedure would work, how to calculate bond amounts under the Act's new provisions. I think altogether, the way they're drafted already makes it more likely that farm workers will be able to exercise their rights under the ALRA if implemented as written. And so we would urge the board to do that. Just in terms of responding to a few of the things that Mr. Barsamian raised during his comment, in terms of adding some kind of additional vote sort of disclaimer on the document signed by workers, the majority sign-up cards, you know, the language in section A1 of that portion of the regulations reflects what's in the bill. We think it's clear enough that when a signer authorizes, you know, when a signer puts their name to those cards, that they're authorizing the union to be their collective bargaining representative, which in our experience working extensively with farm worker clients in the farm worker community, we think that complicating that language, adding all sorts of disclaimers and things like that would only muddle up what the purpose of the bill was and make it more likely that there'd be some kind of confusion about what the purpose of that card is. But beyond that, I think a change to what's required, sort of bringing up the threshold for what's a valid card under the new bill feels more like a legislative change than a regulatory change. And so setting anything that's a higher bar doesn't feel appropriate for you know, this regulatory process. Similar thing with the withdrawal forms that are being proposed. That feels more like a legislative change than a regulatory change. What we don't want, and what has been pretty, you know, common practice, is for a petition to be filed and then captive audience meetings to happen, 4 persons asking for workers to assign saying something that you know, the petition that was filed contained something that was against their will or things like that. So the way that the bill is set up is pretty clear on how you know, representation happens, what the way a worker expresses their intent, and adding something like this feels like a legislative change. It's a big enough change that it's not appropriate for the regulatory process. Mr. Barsamian made many comments. I'll try to respond to just a couple of more. In terms of the potential for extending timelines for submitting employer-provided signature comparisons or anything else, similar thing, not contemplated in the bill and would undermine, you know, the quick timelines that are established in the bill. In terms of employer-provided signature comparisons, I mean, the regulations as written already provide for you know, the employer to submit objections alleging misconduct. And so if there's some kind of concern about whether signatures match up, you know, the bill provides for the objections process to be used for that. I don't see anything in the bill that would allow for some new special process regarding the validity of signatures and things like that. So overall, you know, the union strongly supports the regulations as drafted, and we would urge this to move forward with the regulations as written. Thank you.
Since it's still fresh, can I respond real quick?
In 1 second, because I just have a question. Do you believe that this statute would authorize this process, this kind of card check certification process, to be used for decertifications?
No, the way that it's written, even just looking at sort of like the noun verb relationships, right? The way that the bill is drafted is for a worker to signal their intent to have a labor union represent them as their collective bargaining representative, right? There's no language about using this process to request decertification or anything of that sort. So pretty clear there for us, no.
Okay, Mr. Barsamian.
And I'll be brief. I just want to respond to a couple of things. Mr. Giasocho is talking about the need to stay within these quick timelines. How quick is it when you obtain a card and you can wait up to 11 months, 29 days before you even use it? This isn't a petition for certification with 7-day elections. being required. If you want quick, go ahead and file a regular petition for certification. As far as mixing up workers, I can't, by having language in there about what these cards actually mean now. For the past, what, nearly 50 years or more than 50 years, all they've been hearing from even the ALRB's own pamphlets is that signing an authorization card or a petition is going to get you a secret ballot election. Now you're not going to explain the difference? What better way to mix up a farm worker? I can't even imagine anybody even making a statement like that. You need to do that in order to make it clear to employees that the law has changed. And it doesn't, nothing in my statement said you're not going to be able to vote. It says you may not be able to vote in a secret ballot election. You need to understand this may be used as a vote. Same thing on the withdrawal. I don't understand why that's a big deal. You're talking about captive audiences. What's more captive audience than having people come in to grab their $600 from Joe Biden and have them signing authorization cards? They talk about a captive audience. I can't imagine anything better than that for getting authorization cards signed. So what's good for the goose, good for the gander. You're going to be standing over them as they actually vote, signing an authorization card. And yet you have a real problem with giving them the information on how to withdraw. As to the question you brought up, Barry, about decertifications. Yeah, that'd be great.
Okay,
It would be great. I think part of what may cause this law to be challenged is the fact that it's not clearly providing for decertifications. There's a lot of other problems. And it just reminded me of another one I forgot to bring up. This highly monopolistic job protection provision about groups of employees having to have filed 2 LM2s or having had a contract, just so traditional unions can keep out any newbies, if you will. I wonder about all those Starbucks kids that didn't ever file a LM2, all of a sudden starting one of the biggest reemergences of unionization this last summer. If they looked at this thing and said, well, I can't even form my own union here, at least I can't even use card check, and working with a Starbucks where we've got people spread out around the city, card check would be a great idea, especially since we're working shifts. If they were under the ALRB, you would be shutting them out. So, you know, that whole concept there is probably going to be challenged in court. There's a lot of stuff that's going to be challenged in court first time this thing comes up. Any authorization cards that don't have language. But I guess just letting you know about that. But one of the biggest problems is knowledge to the employees. And filing objections later. If I heard Edgar correctly, you're saying let's go through the majority support petition. Let's have the RD decide, oh, they're certified. And then you want us to turn over signatures as an objection? Talk about bass backwards. That's always done before. The challenges take place before anybody even got a secret ballot to go vote with. I mean, talk about extending things out. You're coming in after the fact saying, all right, you've already certified the union. You've got time running now under the MMC provisions. You've got all these other things that have been triggered. You're saying none of that's going to be delayed by the objections. And now you want us to turn over the signatures? No, absolutely. I'm using this in a nice way, asinine. That just doesn't fit in any universe. Thanks.
can I just ask you a question, Mr. Barsamian, about that? Since the union under this circumstance controls the timing of when they turn in the cards, how could you even have a process under this statute where the employer would file objections regarding the cards before they were turned in, since they don't know when they're going to be turned in? It's kind
Oh,
of,
I'm saying once they're turned in, and we're talking challenges when we're talking signatures. I don't think that's an objection based on conduct. That's a challenge based on, is this even the person? Okay, that I wouldn't say takes place before they turn them in. That would have to be done. That's what I was saying before. That has to be done at or near the time of the employer's response. But extra time might be needed for the regional director to do that. What I heard Edgar saying is, no, you can raise that after the whole decision on whether they're certified or not, presumably even after the extra 30 days they get, before you even look at signatures. That's an objection. It's not. It's a challenge. That has to do with the employee's right to vote, whether it's by secret ballot or a card check. That has not a damn thing to do with the conduct as far as the process. Two different animals.
Okay, I understand that. So you, and I do also understand Mr. Aguila Socho's comments about sort of what the statute says. It's pretty clear in my mind that at this point, but with regard to conduct, if employer believed that a union was obtaining the signatures during the process, they found out that the process, and they believed, for example, or wished to allege that the union was intimidating people or giving them some unlawful inducement, or something that would affect, there's nothing that I see that would prevent them from filing an unfair labor practice charge at any time if they had evidence of some unlawful conduct. I don't think that the employer is foreclosed from raising questions related to conduct.
No, and that's typically that happens. You get a ULP. It takes a while for that to be investigated, although, now we got this long period of these cards being good for 12 months before they were even used. The worker didn't even know where they're going to work or in what commodity or in what location in California, and they're already voting for a union. But many times, you could look back at some of the most significant cases over the last 10 years, the allegations that lead to a ULP are the very same allegations that lead to an objection to an election. And that's what Todd was talking about, consolidation. That's where that typically happens. And that's where the executive secretary, for instance, at Gararan, literally went through, looked through a bunch of the ULPs, looked at the objections to the election filed by both the employer and the union, and matched them up. Didn't deal with ULPs that had nothing to do with the election, matched them up. That's where the big consolidation case came from.
Okay. All right, next person, Santiago.
Next in the queue is California Farm Bureau Counsel Carl Borden.
Good morning. Thank you for this opportunity. I am Carl Borden. I'm Senior Counsel with California Farm Bureau Federation. Just a few words about what that is. It's a nonprofit agricultural trade association representing farmers throughout the state, regardless of commodity. Technically, California Farm Bureau has 53 members. Those are 53 separately organized county farm bureaus throughout the state, which among them count as agricultural members more than 21,000 persons, entities, and individuals. So I won't drag this out by repeating what Mr. Barsamian said, in which I and my organization join wholeheartedly, but I would like to augment on it and also address what I understood Mr. Aguilas Ocho is saying about the authorization cards, and specifically that because with what they would both he and Mr. Barsamian referred to as withdrawal of authorization, I'm going to call revocation of authorization, because that's the term that is used in court cases and agency decisions that have taken up the issue in the context of both the National Labor Relations Act and also under our California Public Employment Relations Board. I appreciate the fact that in drafting the proposal, you folks at the ALRB, we're trying to just follow your current regulation provisions with respect to secret ballot elections as much as possible. I don't think we can do that. That's because of the monumentally different purpose of these employee authorizations, whether they be by cards or petition, excuse me. Of course, under the secret ballot election process, I've reduced that when I talk about this to a two-step process. The first step is the labor organization union gathers sufficient authorizations to show interest. Showing of interest is the term used to have an election. That's the first step. If the ALRB regional director is convinced that there is such a showing of interest, then an election is held. Step two, where the employees can then make a real-time, fresh expression of their sentiments about unionization. That is not what we have under card check. The cards executed and given to a union that could be as much as 12 months old do not necessarily reflect the current, at the time, when I say current, I mean at the time the union files its petition for recognition with the ALRB. The employees' minds could have changed. Either they don't want any union anymore, they don't want to, or just that particular union, and may want some other union to represent them. I hope that Mr. Aguirre-Socha was not suggesting that once an employee signs an authorization, that it is forever, that it is irrevocable. The AB 113 does not talk about the duration of the employee authorizations. It merely says that upon a union showing employee majority support to the ALRB, that it will become certified as the exclusive bargaining representative of an agricultural employer's agricultural employees, bargaining. So I'm stressing this to highlight the difference. With respect to secret ballot election, it doesn't really matter so much if an employee no longer wants to have that designated union, the authorized union, to be the representative, because if there's ultimately an election, a secret ballot election, that employee, as well as the employee's co-employees, can express their then real-time fresh expression as to their sentiments about unionization. Again, that's not what we have here. And so going to one, and we will of course be submitting once the regulatory package comes out and formal public comment period has opened, we will be submitting specific comments and proposals for amendments. So for example, under A2 of the proposed regulation, which is based on the same language, the current regulation for secret ballot elections, no employee authorization more than 1 year prior to the date of filing of the petition shall be counted to determine a showing of majority support. Well, I suppose that would be okay, except for the fact that the legislation has this plan B, where the union, where the ALRB determines that the union fell short of proving majority support, and the union is given another 30 days. Now, 30 days may not sound like much, but it's possible that a substantial number of the authorization cards were issued in the 12th month before that petition for certificate, before the majority support petition was filed. It's our position at the Farm Bureau that that language should be changed so that that it takes into account the freshness, the validity of the cards, the 12 months that the cards had to have been issued within 12 months, or the authorizations given by the employees within 12 months of when the board makes its final determination as to whether there in fact is majority employee support. Going back to this question of employee right to revoke authorizations, the statute is silent on that. It just talks about the ALRB evaluating whether there is proof of employee majority support for a union. That is kind of in line with what employers have been doing under the National Labor Relations Act, where they have, of course, voluntary recognition, where the union gives cards to the employer for the employer to compare and make the evaluation, and the employer could, it's not required to, the employer could choose to voluntarily recognize that union without an election. Under our California Public Employment Relations Board process, it's a bit different. There, if the employer is presented with cards expressing majority support by its employees for a union, then the employer must, it's mandatory, the employer must recognize that union. In cases that I was able to find, and I'll cite them not now, but in our formal comments, the questions had come up about the validity of employee revocations of their prior authorization. How is that effective? In one case under the California PERB, the question was a mere writing on slips of paper, no union enough to revoke the prior authorization of the union. The PERB held no, it wasn't, but that specific statement that was actually provided to the employees by the employer in an email to them, because the employer was not sure of whether slips of paper saying no union were good enough. A handful of employees did say, I hereby revoke my authorization of the union. There was no, allegation that the employer had engaged in any unlawful, coercion or intimidation of these employees, but merely said, hey, if you really don't want the union to represent you anymore, please let us know, because we have to make this decision. Likewise, under the National Labor Relations Board, there's at least one case where the employer had to make that same type of determination, whether a prior authorization given by employee remained valid. So getting back here, so since it's not going to be the employer, of course, under the ALRA's card check provisions is making the determination, but a regional director of the ALRB, that regional director should be provided with the means of making a quick and clear-cut determination as to the validity of any employee withdrawal or revocation of authorization. And if not put in the reg itself, which we do support, and we'll try to develop some appropriate wording to that effect, unless you folks at the ALRB like, or not like, but recognize what I'm saying makes sense and included in the regulations. At the very least, there should be a form that would be posted on the ALRB's website, and that might come as a result of a regulation provision as well, that by which the employee can withdraw, notify the ALRB of withdrawal, revocation of authorization. Think about in terms of during this 12-month period where there may be one or more other unions at play. who might be interested in organizing these workers. And those unions might be able to, might make a better pitch to the employee. And the employee says, boy, I like what I'm hearing better from this Union B as opposed to Union A. I want to sign an authorization card. If there's not, for Union B, if there's not specific language that is included, say, on the card, that by signing this card, I revoke any prior authorization I may have given to any other labor organization, the regional director is going to be in a difficult position to make a determination as to whether employee authorization remains fresh and it hasn't been revoked. It should be, as a provision on the card, it should actually say that how, or that you may at the very least revoke this, and how it can be revoked. I don't think it has to complicate things too much. If it refers the employee signing it to the ALRB website, or if the concern is that it's going to complicate what's on the card, it may even be more effective since the employee doesn't retain that card but gives it to the union organizer. But if the union were to be, I know the union won't like this, but to have to give to the employees an ALRB approved form that tells employees, what it is that they've done, and if they choose to no longer want to authorize that union to be the employees' collective bargaining representative, how they go about revoking that. That's all I have. We'll entertain.
Thank you. Who's our next person in the queue?
Next speaker will be Maribel Ortiz.
Sí, hola, buenos días.
Buenos días. Espere un momentito, voy a coordinar con la intérprete. Okay. Interpreter. Yes, thank you.
Oh, sí, mi nombre. Sí, buenos días. Mi nombre es Maribel. Vivo en Delano, California. Trabajo en los campos aquí en el área. Pues, y también en otros trabajos como en temporada de boda y así. Y sí, yo y mis compañeros hemos estado organizándonos por años en la uva de mesa. Hay tantas injusticias, bajos salarios y no tenemos beneficios. Hemos querido organizarnos, pero nunca hemos podido por tantas represalias. Campañas que hacen a las compañías para que no nos organicemos. Para mí es muy importante la AB 2183, la ley que acabamos de pasar, porque con esta ley yo y mis compañeros tenemos una esperanza que con esta ley vamos a poder organizarnos. Para mí y mi familia es muy importante tener representación de unión. Gracias.
Mary, do you want me to cue the next speaker?
Yeah, although I didn't hear the translation.
Okay, I was able to hear it. Was anyone? And just a reminder, folks, to be sure to choose the English language setting at the bottom of your screen. Clicking on interpretation, choose English to ensure you can hear the interpreter.
Yeah, I was able to hear it. Just
Okay,
so-
I'm sorry, I must have not chosen it. Oh, is that under interpretation?
Yes. choose English there.
Oh, yeah, I had original audio. Okay,
Okay.
thank you. I'm
I,
sorry.
I actually have it chosen and I didn't hear it.
Okay, well, we have a recording, so we'll be able to share with you, Elise, and then Barry, if you'd like, I can call the next speaker.
Yes, please.
Right, next speaker is Susana Ortiz.
Buenos días. Mi nombre es Susana Ortiz. Soy campesina y pues yo trabajo aquí en el área de Delano, California. Y pues para mí es muy importante de que haya pasado la nueva ley, la AB 2183, pues para poder tener mejores condiciones de trabajo, para así no tener para mí, mis compañeros, no tener represalias y sentirnos más seguros de poder tener representación. Y pues tenemos más esperanzas de poder tener mejores sueldos, mejores tratos. Y pues aquí estamos para poder seguir con lo de la nueva ley. Gracias.
Thank you.
That concludes the speakers that were in the queue at this time. Barry, if you like, you can call on others in the Zoom meeting to indicate whether they want to make public comment.
Is there anybody else that wishes to make public comment at this time?
I'd like to just make one comment that I don't think was been covered yet.
And that's Patrick?
It is.
Yeah, okay.
The one thing we heard some talk about the time issues and wanting quick results and whatnot. I think one thing that's important to note is that the 48-hour response time that's in here, and again, that I understand that was in prior issues, but one thing that hasn't been considered, I don't think, is the fact that there's no regulation on this and there's nothing written, but from an employer perspective, I've been doing this over 31 years, and we get everything either from the union or from the board on Friday afternoon at 4 o'clock that requires a 48-hour response time. And it sort of obliterates the response time where you've got an intervening weekend. I just think that's something that needs to be considered and addressed in some fashion.
Thank you.
Mr. Broad, this is
Sure.
Matthew with Western Growers. Can you hear me okay?
Yes,
Yeah, I just, in the interest of time, I would just, I wanted to thank you for the opportunity for the workshop today. And everything that I was going to comment on was covered by Mr. Barsamian. And so I'd align our comments with his, and I couldn't say it any better. Thank you.
thank you very much. Are there other people that wish to comment? Okay. hearing none. Oh, I'm sorry.
Cynthia, yep. Cynthia Burgos would like to make a comment.
Yo tengo un comentario. Yo soy campesina de acá de la ciudad de Bakersfield. He trabajado las corridas desde Los Ángeles hasta Salinas, California. Soy parte de, ¿cómo se dice? Voluntaria en la Unión de Campesinos, y yo marché 335 millas, 24 días para la AB 2183. Estuve 30 días viviendo fuera del Capitolio hasta esperar que el señor Newsom firmara la ley. Ahora sé que soy parte de esa ley y a tratar de implementarla porque en el campo hay muchas injusticias, demasiadas. Yo fui víctima de violación y eso fue una de las cosas que me hizo marchar por más derechos, porque se me hiciera justicia. Y pues ahora que veo que podemos organizarnos sin tener miedo a represalias, ni mucho menos a aguantar personas que nos hostiguen, estoy contenta de haber sido parte de esta marcha y ahora de esta ley. Y invito a todos mis compañeros a que no tengamos miedo y nos organicemos pronto en el FIL también. Gracias.
Thank you very much. All right. Are there any further comments? Going once, going twice, going 3 times? Okay, so we're now, if there's no more comments, we're sort of at the end of the process, or our informal process for today. We'd like to give everybody a week, and given the last comments, why don't we say that we'll have all written comments to the committee. We'd like them in by noon on Friday of next week. That's June 30th, if I've got it correctly. And then we will be able to sort of review those as a subcommittee and make any changes that we would like to recommend to the full board based on the comments received. If the changes that you've requested are not in there and our regulation goes forward without something that you want, you'll have every opportunity, if the board moves forward with the regulatory package in a form you don't like, as we said before, to repeat any changes that you request, any changes that you want, or raise any new changes, or anything that suits your fancy. You are will be entitled to present before the board. I just want to thank you all for participating today. The comments, at least from my perspective, Ralph can comment too, but at least from my perspective, the comments that were made were very helpful. And I very much appreciate your willingness to get down in the weeds, so to speak, about specific issues and problems that you see in the statute, because that's helpful for us in formulating our own view on what to do or not to do as we move forward. Ralph, do you have a final comment?
I would just join in that. I would like to thank everybody for participating. I thought it was very helpful to have people's views expressed, and to urge you to, there are, as Barry says, there are several steps in the process where there's not further opportunity to comment in writing or orally, but getting written comments in early, or citing cases that you refer to and so on, that I think Carl Borden mentioned the case, is useful to us to hear that stuff. So
All right.
I hope you'll those who are so inclined would file written comments too. Thanks.
Thank you, Ralph. Again, thanks to all of you. And I think that with that, we can conclude our meeting. I hope everyone has a nice weekend. Thank you.
Thank you.
Thank you.
Bye-bye.